How far did we get the other day? Negligence, did we talk about? We got right to negligence. We talked about vicarious liability?
We did. We talked about misfeasance and malfeasance.
We did talk about vicarious liability.
Vicarious liability? Statute of limitations, we didn't get to that, did we? We got right to here, I think. Interrogatories, I don't think we talked. We talked about malpractice? We talked about 4 things in negligence? Yes, 4 things that you had to show cause? Okay, I think this is where we ended up, actually. Grab. All right, we talked about malpractice, right? Yes? Okay. All right, we're almost done with this. Any questions about anything else? I'm trying to get your job descriptions and stuff done, but you know that Springboard has not been cooperating. So I can't get in there. Every time I get in there, I get logged out and kicked out because of some internal error. So the latest thing is that they are working on a hot fix, whatever that means. That must be like IT jargon for fixing the problem because everybody's sending them so many emails complaining. So I'm getting to them. As soon as I can get in there and do that, I will get those to you. The Facebook pages to comment on. If you somebody actually opened up a discussion page and people were posting over the weekend, so if you put yours in there, that's fine. But if not, I opened up a discussion page for section 002. You go to discussions, and in there you'll upload your PowerPoint slides of your Facebook page, and then you'll open up any other 3 random people's, and you'll comment about theirs. And then I'll go through and grade you on your page and on your commenting 3 other people. Questions about that? You have until December 5th, the last day of classes, to comment on other people's. Okay, if you put you probably put it in your Facebook page in the Dropbox already. Whether it was in the Dropbox or in the discussion post, as long as it was there by the due date, I don't care where you put it, as long as it was uploaded by the due date. So, because I know some people only uploaded theirs to the discussion posting, and that's okay too. Stephen? It is due on Thursday. Yours will be due on Thursday, the 5th, I believe, of the semester. By 4:30 p.m., downstairs on the 3rd floor, there'll be a box down there. Deanne already told me today, just because your students know that the office is open till 5, she will not be opening the door to you at 4:31. So they're due by 4:30, not by the closing of the office date at 5. Because she doesn't want to have to sit here waiting for all of you people that are still working. So she threatened me, which is why everything actually is due at 4:30, because she got mad having to wait in the office till people ran in the door at 5 after 5 and 10 after 5 and such. So any questions about that? Okay. Next week on Tuesday, I believe the Career Center person is here. And then I believe what I will do is not have class that last day of class, but I will open up the quiz, or the 50-point O&A question bank that you have to take. We'll call it a quiz for lack of any other terminology. Let me finish. But there will be 50 questions that you will go to the quizzes section, and you'll open it up, and you'll sit down, and you'll answer the 50 questions. You will get a grade, or you will get a score based on those 50 questions. It is based on information that we have covered and we have talked about this entire semester to gauge your grasp of O&A terminology and content. Your score in the grade book will not be the score that you receive on the question bank. Okay? You'll get 50 points. It's either a 0 or a 50. You either participate by the deadline or you don't. So it's 50 easy points for those of you that need those points. Okay? And that'll be open 1 week. It'll be open from probably Wednesday to Wednesday, so you'll have 7 days over that course of time to be able to do that. So you're not pigeonholed with all of your other exams and projects and things. Amelia?
I was just going to ask about the notebook. Can we get, if I would like mine back, can we do that during finals week?
No. You will have to come back after Christmas break and get it. And I'll put out an email that says, because those are yours. I would like for you to take them If you don't take them, they go to notebook heaven in the MSA room, and they get used for other people to look at for next semester. But those of you that want yours to show somebody work that you've done, then you are more than welcome to get those. But grades are not technically due till after finals week, and then the holiday sets in and the university's closed, so it's easier. But at any time after the next semester, you can come back and get them. Any other questions I can answer for anyone? Everybody's got their manuals done, Rockstar, ready to go, ready to turn in, just doing finishing touches, like a little tweak here, a little tweak there. Right? 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 Some minor changes, right? Exactly what I want to hear. The stubborn envelope? Emblem, yeah, that's the way it is. So hopefully you've gotten to do some things that you haven't had to do before this time, and that's a lot of the purpose of that, is being able to actually leave here having done things, so when you one day are a student and the next day you're an employee, you can hit the ground running and be able to do some things your boss or your employer or grad school asked you to do. All right, let's finish up legal terminology. We're almost done here. We're going to talk about risk management. I will try not to be too wordy. I see the snow is coming down, and everybody, except for those of you that are in my classes tomorrow, everybody wants to go eat turkey or at least start their festivities. So I'll get us moving. All right, we talked about where law came from last time. We talked about some terminology of law, about malfeasance, misfeasance, and nonfeasance. And we talked about negligence and the 4 elements that you have to show to prove negligence. It's a lot harder to prove than it seems, because the big piece in negligence is proving cause and effect. Exactly what you did or what you didn't do causes someone to incur damages, and then you have to actually show what those damages are. So there are some things, if you ever get sued, and some language and some terms that we should be familiar with. Okay? If you get sued and it actually ends up going to court of law, where you have to sit in front of a judge and a jury of your peers and things like that get selected, there are things called interrogatories, and there are a whole bunch of steps that happen before that actually takes place, where people actually, and the attorneys actually write questions that you have to answer under oath. And sometimes those are videotaped, and sometimes those are just questions that you're given and you have to provide written answers or typed answers to. And then the attorneys go through all those, and they actually decide whether or not there's enough information based on that to pursue moving forward with the case or not. Okay, so that might be something that you actually have to do. And that's one of the reasons why documentation is such an important piece that you're going to see in the risk management piece, is to be able to do that. Because you are not going to be able to remember, if you treated 40 patients or 20 patients in a day, okay, and you didn't chart every time that you did or treated those patients, the next day you are not going to be able to remember every single thing that you did with that patient and everything that they said or they told you or that happened, let alone a week later or 2 weeks later or a month later or 6 months later when you have to actually answer these questions. So it is of utmost importance for you to be able to document, and not only that, but to document things that actually happen. If patients told you things, you know, about what they did or didn't do or felt or signs or symptoms, you got to make sure that you write that in that subjective portion about what the patient actually said to you. Okay? Then there's what's called discovery. And discovery is where everybody has to disclose everything that they have about their case. So Corey is the attorney for Tyler. He has to disclose everything to Kurt on the other side of the table that he has. And if he doesn't disclose every piece of information that he has, you know, some of this is from courtroom TV drama, he can get into trouble, because there aren't supposed to be any surprises when it comes to court day and presenting your evidence. The other team, the defense, has to be able to prepare and rebut anything that you say. You know, and if you've ever seen, that's what law clerks do. People who are going to law school, that's entirely their job, is to take that discovery of information and to research it to the nth degree so that there aren't any surprises on jury day as to who did what or who did when, and to be able to find it. Have any of you ever seen A Few Good Men with Tom Cruise? Okay, that's a really good movie, and it's all about, it's even though it's set in the military setting, and they have some different rules as far as military court goes, but that's a really good courtroom drama over the course of a movie, to be able to see how information gets disclosed and how all of the research that goes into actually proving a case. And sometimes you can prove it and you can feel like you have all the information that you need to say that this person caused damages, what they did caused damages, and damages were shown, and the jury will disagree with you because of what you presented or how you presented or the emotions that came into the case. So discovery is when everybody has to disclose whatever they have to everybody. And again, you can get into trouble if you don't. A deposition is when you kind of go into court, and then it's kind of like pre-court, where you go in front of attorneys, not necessarily a judge, but you go in front of attorneys, and they ask you questions orally or out loud, and you have to answer those questions. And there's a court reporter there that takes down all the information and everything that you said. Sometimes they're also videotaped, so that they can go back and they can dissect every word you said and how you said it and the emotion that you displayed in that, to dissect so that they can prepare for actually their day in court. So again, those are some terminology that actually, when it comes to litigation and litigating it or actually presenting the case in court, that you may have to provide. And that's after you have to provide all of the documentation. You would have to provide all your chart notes, any information that you have on that patient first, and then they decide what questions they're going to ask from there, and then they move forward into the legal process. Okay? Some other things that are out there, statute of limitations, that means that you only have a certain amount of time in order to be able to bring a lawsuit against someone. If you want to file a legal case from a car accident, somebody rear-ends you, Sarah, or somebody gets you into a car accident and bashes your car up and causes all kind of damages to you, you only have a certain amount of time, and I want to say it's 2 years or 3 years, to be able to file that claim against that individual. 2 years. I thought it was 2 years. So you can get in that accident today and go through all that stuff and not file any claim until the day before it's going to expire, which makes the other person really pissed off because they're thinking that they got away and they're not going to get a lawsuit filed against them. But you don't have to do it right away, but you do have to do it within that time frame. And then once that time frame starts, all of that discovery and all of that other stuff takes place. But keep in mind, during that time period, up until those 2 years, you're getting treated and you're accruing bills. And that's one of the reasons a lot of times they don't want it to go to a legal case, so they'll ask you to settle. They'll say, you know, well, you've already, you know, here, we fixed your car, and we paid some of your medical bills, and how about today you sign on this dotted line that says you're not going to sue us? And what happens if you do that, Sarah? What happens if you do that? If you sign on that dotted line and say you don't want to sue because you got money for your car and for your present medical bills?
And you lose out.
And you lose out because what happens to you later?
You have further complications.
You could have further complications, and you could need another surgery that you didn't anticipate, or something bad can happen, and you've given up your rights. So a lot of times that's why people wait to file a lawsuit, because they want to incur, see where they are going to be physically before they actually file the lawsuit, before they...
So, okay, say in that...
Remember, I'm not an attorney, and I don't even play one on TV.
Right, but if you have those 2 years to file, and then, like, with me, like, this has been 3.5 years ago.
Can go on forever.
I mean, and
Not
I
forever,
have
but it can go on for a really long time.
surgery, so they could still have to cover that if I filed that lawsuit, but within that 2 years, as long as I filed it within that 2 years, then it would still.
Yep.
Okay.
Yeah.
I don't know how that works with that.
Yeah, it can drag on forever. They cannot settle. You know, your attorneys can say, we're not going to settle, and they can keep that claim open, you know, as long as it's filed. They can keep postponing and keep pushing and keep letting it drag on forever and ever. So that's one of the reasons why there are a lot of healthcare providers, like physicians and physical therapy clinics and chiropractic clinics. There are some people that won't take legal cases like that because a lot of times they don't get paid until the case settles. So if that case doesn't settle for 3 years or 4 years or 2 years, you're out $10,000 in physical therapy treatments that you're not going to see until that case settles. And then if it settles, that doesn't necessarily mean, if you can't prove cause and effect and damages, they can say, well, you know, even though your medical bills are $400,000, we're going to pay you $1,000. Our estimates, based on all the things and all the pieces and parts that came together, we're going to give you $100,000. And so then you're left to divvy up that $100,000 between all of your expenses. So you can actually, I don't want to say lose money, but you can actually be in a bad case scenario, not even having all your bills covered, depending on how good your attorney is. or not. And I worked in the physical therapy clinic where we literally treated people for, a year and ended up having, to take a measly amount of, $2,000 for $10,000 or $15,000 in physical therapy services because you weren't going to get any more. Now you can sue or you can take the individual to collections for that $9,000 that you didn't get, but again, that's a whole other legal process, and you have to be able to have the manpower to do the collections type piece. Jen?
Medical insurance in general isn't like car insurance where like fault is involved, right?
Correct.
Okay.
Correct.
Unless you don't cover, like your medical insurance doesn't cover all the bills and then you want to sue somebody. Does that have to be their fault?
Well, you don't get to, are you talking about if you're harmed from?
Like in a car crash and it wasn't your fault, it's the other person, your medical insurance would cover a certain percentage. And if it doesn't, that's when you would sue somebody else.
Right, or you literally, ideally you wouldn't have to sue them. If somebody else hit you, you exchange information, your insurance shouldn't pick up anything. It should be their insurance that takes care of you.
Their medical insurance?
Their car insurance. Their car insurance should take, and they should have a piece to it. But it's when you don't get all your bills paid from them that, or they refuse to pay because they say, you know what, we're going to fight that. We're going to say it wasn't really your fault. It wasn't really our fault. There's no police report, so we're going to fight it, and then you end up having to sue them. And there's a number of different things that can happen. But there are some healthcare practitioners won't necessarily take legal claims for that reason because it's sometimes a really long drawn out before they actually get paid because there can be some of those complications. So just know that statute of limitations usually within 1 to 3 years, and typically when we're talking about malpractice and negligence and things like that, 1 to 3 years. So, you can't wait forever to find out that you're disabled. You have to know earlier on and be able to go through those because there's that discovery process. Now, if you commit murder, what's the statute of limitations? What do you mean by that? There is no statute of limitations. If they find out 40 years from now that you murdered somebody in a cold case, because those cases are special because they've waited longer, just like the TV ad says. Now I'm a big Criminal Minds junkie, so I'm on that station all the time. They can come and get you 40 years from now. They just found somebody. They found all those bodies in that New York house, and they actually found the guy, or tracked down the guy that did it, and it was like 40, 50 years ago. So, yeah, if you kill someone, you're all looking over your shoulder. I heard a story the other day about they found that guy, that Ray Bulger guy, who was the mob boss, living in Santa Monica because there's a lot of transient people there. And same thing, he had ordered the hits on, a bunch of people, and he's 80 or 90 years old and living with his wife and some cats in a little transient housing thing, and they just arrested him, and they're going to send him to jail or whatever. So if you kill someone, no statute of limitations. In healthcare, there is a statute of limitations for negligence and malpractice. So if you get injured, you can't wait 20 years to say that the surgeon botched my surgery. You got to do it sooner than later. Now, Good Samaritan laws. Good Samaritan laws. If you come upon, one of our athletic training students came actually upon a car accident of a burning car and actually pulled someone out of the car before EMS could arrive. Now, if he were to break someone's leg while he's pulling them out of the car, he didn't, but if he did pull somebody out of the car and broke their leg before the EMS arrived, would he be able to be sued? Could they sue him? How many say yes? You could try. How many say you could try to sue him? Yes? Okay. How many people say no, you're protected? How many people still want to answer because they're not really sure? It's one of those gray areas. Corey? I see the look in your eye. Now, keep in mind that Good Samaritan laws are most states, and they do provide a limited protection. Okay, they give you some limited protections for helping people in an emergency or in disaster. You can't take any money. As soon as you take money, then that entirely changes and you're not a Good Samaritan anymore. So as long as you willingly stop beside of the road to help somebody out of their burning car, you can be protected by from liability, because you're providing first aid. And again, you have to keep in mind, though, about the scope of that. Remember, because if you are an athletic trainer and you stop, you still are held to a different standard than you are if you are just a lowly, generic person who knows first aid and CPR. Okay? You still, as an athletic trainer, cannot take the pen and cut them opening in the neck and put the pen in and breathe for them. That's outside of your scope of practice, unless you're in Iraq or somewhere else. Okay, so remember, you have to choose activities that are going to be considered reasonable care in that situation. And you have to remember that reasonable is a very, I don't want to say loose term, but somebody is going to interpret what reasonable means. Jen, you had your hand up?
So if something's in your scope of practice and you didn't perform it correctly in an emergency situation, like you didn't stabilize their neck correctly or something, could you then be sued even though the general public might not know that?
Correct, because you hold a license. So if you were a nurse that came up to a site, you know better than does somebody majoring in sports studies who doesn't have any medical background whatsoever. Now, they're not asking you to do necessarily nurse functions. Like I said, they wouldn't expect you to put a, trachea tube in somebody, but they're expecting you to do first aid in an emergency or a disaster. Okay? So as an athletic trainer, you would or should stabilize their neck unless the car is burning and they're going to die in the burning car. Then, they can still sue you for paralyzing them, and you could go to court and they could say, well, I could leave you in the car and you would not be a paraplegic, but you would not be suing me in court, and that would all come out. So again, it's about reasonable first aid in an emergency or a disaster scenario.
When I was in first aid CPR, my teacher told us that someone that had a CPR license or whatever gave some because he was choking, and then they ended up suing them with a broken rib.
Yeah. Yeah, and that doesn't mean they ended up suing. Can you say it louder?
They gave them CPR and broke a rib because they were choking, and they ended up suing them for breaking their rib.
And again, you can be sued. That doesn't mean you're going to lose, but someone can sue you because now they have medical bills from a broken rib. Now, they could be dead, but they were greedy because they sought an opportunity, and, they probably were injured and they probably did have some medical bills, but they could have been dead. But they were not appreciative. So, again, generally, if you are acting ethically and morally and within your scope of practice and doing the right Good Samaritan thing, you will be protected from the law. And protected from the law doesn't mean that somebody won't sue you, but hopefully it means that they won't win if they sue you, which, a lot of times doesn't help you because you're still going to incur medical costs defending yourself, which is why sometimes people question, why would I stop? Why should I?
Now, do most of those cases that, they save someone's life that end up, breaking a rib or that broken leg, then do those, do those cases win?
I know that case did not win.
It did not.
I would suspect no, because it's all going to come out in a legal process. And again, as long as you are within your what a reasonable person would do who voluntarily showed up in that situation based on what your scope of practice is. If you're a nurse, we wouldn't expect you to pull oxygen out of your car and start breathing for the person, but we would expect you to be able to do first aid and CPR and assess the situation differently than someone who has no background whatsoever. But again, that doesn't preclude you from being sued. Hopefully it precludes you from losing that lawsuit. Okay? So sovereign immunity, I don't know if you have ever heard this before, but a lot of times people who are foreign dignitaries from other countries, or whether we are foreign in another country, we will claim that we have sovereign immunity, and that means that doesn't matter what you do, but because you're a dignitary or you hold some federal or state employee, you are immune from being prosecuted or having legal action again. And again, sometimes you can be protected. It's not a great defense, particularly if you're doing something really wrong, like murdering someone or embezzling money or things like that. But federal and state and employees have some bit of immunity when it comes to legal defense. Again, but you have seen, some people still get into trouble by crossing the lines, but they can use that as a defense, or at least a first line of defense. It doesn't necessarily mean it's going to be work for them. Okay? Now, some things or some problems that people have and why they end up falling out of their chair or being litigated against, and some things that you can do. And again, this isn't a total risk management thing, but it's going to kind of lead us into risk management, is things that you could do as an employee or as an employer. Okay? If you know what all of you have developed a facility in here, and if you are the creator of jobs in your facility, it's a whole lot easier to make someone accountable if they know what's expected of them, right? If you just say, just show up for work and you'll learn on the job, you're going to be treating patients and exercising or rehabilitating patients, it's really hard to defend that if somebody brings a lawsuit against you, because they really don't know what their job or what their role is. So when you go to work in a place, you should find out what your responsibilities are. One, so you can be evaluated and get raises and know what your expectations are. Two, so that, again, that's how employers get sued, because they don't have job descriptions and people say, I'm out of my scope of practice or whatnot. Maintain your first aid and CPR certification, have your emergency action plans, have consent forms and waivers and screenings with PAR-Q. Again, a PAR-Q is not enough if you're going to treat people. I don't care whether you're doing personal training, I don't care what it is. All PAR-Q does is tell you their risk of having a heart attack in your facility. And a lot more things can happen in there. There's nothing wrong with having a basic 5-step fitness screening. One, because how are you going to know where that person is baseline and prescribe exercise or physical activity for them if you don't know where they're starting from? Okay? It doesn't have to be fancy. You do your history, cancer, osteoarthritis, diabetes, anything that's going to get in the way of their physical activity. And then you do 5 steps of physical activity: flexibility, muscular endurance, body composition, strength, and what's that one? And cardiovascular fitness. So simple. And that protects you. You did what you were supposed to do from square one. If they have a heart attack or if they develop an osteoarthritic problem from there, not your problem, because you knew that they had that condition and you designed appropriate activities based on that. They can still develop it, but you at least did up front what you were supposed to do to protect yourself. Pre-participation would be a screening. Document all injuries. Every emergency action plan should have an incident report in it. Somebody trips and falls on the weights and cuts their finger open. Somebody dislocates their shoulder. Somebody slips in the bathroom. Somebody drops the weights on their head and gets stitches or is bleeding. Okay? Document it, report what you did, and follow up with that person. And that's probably as important as documenting, is calling them the next day or following up with them. And again, it shows that caring side, that I really care about your well-being. And if you follow up with them, they are much less likely to sue you because you were concerned about their well-being. Okay? So document. Same thing with bloodborne pathogens. If somebody has blood, again, and they're bleeding all over the place, you got to document it, because you don't know if they have hepatitis or if they have tuberculosis or if they have HIV or whatever. And it's not necessarily that you're covering your ass. It's about user safety and user satisfaction. Okay? And you should never, ever, some people will, but you shouldn't be an employee or an employer based on covering your ass. If you do what you hope to do and be a healthcare practitioner and be ethical and moral and try to do the right thing all the time, then you won't run into trouble most likely. Update your education, because things change. Make sure that you're training your people on emergency action plan and blood things. Make sure you inspect your facilities and equipment for broken cables so that that cable doesn't break on somebody. And make sure that people communicate. And that's the following up thing. And it's also with your patients and with your employees. If you do these 9 things, you may still get sued, because there are no guarantees, but you won't. Chances are that it's not going to go so far as to you having to defend yourself and spending a lot of money, or they're not going to win, because you will have everything that you need. All right, these are some common things. They're taken from some cases about what happens to people and why people got sued. The individual failed to obtain informed consent, and then a bad result happens. You fail to tell somebody that if they stop walking when they're on the treadmill, they can fly off the back of the treadmill and break their arm. Okay? It is a risk. Now, generally most people are not going to do that, but in my house, my youngest son, we call him the Tommy factor because you never know what's going to happen with him. And so being, we're all about physical fitness and we all like outdoor activities, and so I was on the treadmill. My son wanted to be on the treadmill. No shirt, bare feet, shorts, on the treadmill. Standing right there. I'm standing right there. He's walking on the treadmill. Oh, let's go a little faster. I can run fast. I can run fast. I think he was probably, 7 or 8. Well, next thing you know, what does he do? He stops walking. And where does he go? Pew, right off the back of the treadmill. But because there's a wall there, he gets stuck as the treadmill is going thump, 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 and he's got, road rash all over his eye, all over his chest, all over his elbow. So, and I was standing right there. But things can happen. Now, that's the risk that he takes being in our family. But, what's that? Yeah, he's got all kind of stitches, and he's the stitches boy, and he's not the spine boarding boy. He's got a number of different stitches. But yeah, he doesn't mind. He climbs. He's all over the place. But again, those things can happen. Even if you're standing right there, everyday things can happen. And you don't want those to happen to your patients. See, I learned on my family, so none of it happened to my patients. But again, same thing. When you go to surgery, that physician is supposed to give you every single risk and complication that can happen, even if it's 0.1%. Because you might be that person that is 0.1% and that it happens to. And if he doesn't and it happens to you, or she, sorry, then that's where there can be issues, okay? Fail to document what you did and what you didn't do. Have any of you ever been in the clinic to trying to chart 40 patients in a day and write down every single exercise that they did? It takes a long time. We used to chart everything by hand, and we used to work in the clinic when I worked. We would close for like 2 hours because there was only 4 of us. So we would work like 7 to 1, and then we would take a 2-hour break, and we'd write all of our charts from the morning, and then we would have work in the evening. But again, trying to write a whole stack of charts like this in 2 hours, remembering what you did from the patient at 7 in the morning, and every single exercise and how many reps you did, okay, it can be challenging. So fail to document what you did or what you didn't do. Fail to follow your own policies and procedures. Okay? If you have policies and procedures, and if they sit on a shelf and your employees don't know about them and your patients don't know about them, they don't do you any good. So everybody should sign off on those. Everybody should sign off the fact that they read it at least once a year. And I know you're all sitting there saying, I have worked in a place and I have never ever seen the policies and procedures. I've never signed off on it. I don't have any idea what it is. Right? I'm sure it happens all the time. So this is where you will be better educated, and you'll be like, hey, I want to go take a look at that and see what's in there. See if I'm doing stuff I'm not supposed to. Here's the big one that I talked about before. If you treat clients like they are unimportant and what they have to say is insignificant, they will not hesitate to sue you, even if you fixed them. Because you might have fixed them, but it might have took too long or it might have cost too much money. If you treat people with the golden rule, like they're your mother, well, shouldn't say that because some of you might not like your parents. But if you treat them like you would like to be treated, and you treat them with respect, and you listen to what they have to say, and you treat them with dignity, again, even if you didn't get them better, they are much less likely to go to court and to sue you than they are if you treat people like they're unimportant and they're insignificant. Okay? If you speak in a superior manner and you are the all-knowing, I am the almighty up here and you don't know anything down here, and I'm not going to take the time to converse with you, that's another way that people won't hesitate. Okay? Refuse to treat a client due to his or her condition. Now this is a sticky one because this kind of falls in the moral, ethical thing, whether or not you're allowed to refuse to treat patients. Are you allowed to refuse to treat patients? Yes or no? It depends. It depends on what? Stephen?
Well, like, there's some, like, relational things that you can't treat.
What do you mean?
Like, I don't know if it's a law,
But,
If there's conflict, there could be conflict.
so if there's a conflict of interest, you're saying it's okay to refuse to treat someone. Is that the new Brazil jersey? Did you get that offline?
This is old.
No.
It's like 4 years old.
It's pretty cool, if you like Brazil. So can you refuse to treat someone? If there's a conflict, you can refuse to treat them, you're saying? You believe that?
I'm saying yes.
Okay. Nothing wrong with that. Why? What would be a conflict that you wouldn't treat someone? Nadal?
Aren't there some rules in the emergency room if you're in the trauma department, you have a family member or something of acquaintance that you know you're not allowed to be in the room?
Yeah, because you're not really objective anymore then. So you can refuse to treat people, even in a physical therapy clinic. I'm pretty sure that you can refuse to treat some people. But you just better be careful about who you refuse to treat and the reason that you do, and you better document that because they can be angry and they can sue you for discrimination. Go
I
ahead.
was gonna say, like, if they're highly contagious, like if they have a sickness, that, like, if you're their physical therapist, like, something that's out of your scope of practice.
Or even if they show up and they're hacking all over the place like they have tuberculosis or they have a skin condition.
Does it put, like, you at risk as well as, like, your other patients?
Absolutely. So you can refuse to treat them, but again, you have to be careful about what that reason is, and you better make sure that you document it. Can you refuse to treat someone because of their skin color? How about their religion? How about their race? No. Okay, those are going to get you in trouble. Cody?
Did you say you can refuse because of what medical insurance they have? There are like places won't accept Medicare and Medicaid.
There are. That is correct.
So you have to offer your care still. You can say it's going to cost you a lot of money.
Yeah, I don't even think that you have to offer your care. If you say we're not a provider for you, then the person would have to pay out of their pocket. I don't even think that you have to offer that up. You don't have to say, well, we're not a provider for you, but you can pay us, you know, out of your pocket, and this is what the rates will be. I don't even think you have to offer that up. If they're not a provider, you can simply say, we're not a provider for your service, and let them go somewhere else. Most people probably wouldn't do that because they don't want to turn away business. But there may be some people, like there are some positions and some places that won't treat Medicaid because the reimbursement is so low, it's not worth their time. Amelia?
What about people that come in that are hostile or just feeling like you're in danger? Can you refuse?
Absolutely. But again, as long as you document that and...
Did you just say that? Or
Mhm.
for certain words they can use?
Yes, you know, just like the active shooter, you want to defuse it before you refuse them, and you may have to have, you know, people helping you. But yes, that would be also to the safety of your patients and other people that are there. Same thing if somebody's irate, or even people who maybe have mental illness that are not in a state of mind where it would be a good idea to treat them. That's another thing. Again, as long as you document it and you make sure that, you know, what you actually did and said is in there, then you can do that. But just know that, you know, somebody may be upset and you may be sued as long as you can defend yourself. Oh, another big one that falls right behind treating people crappy is the breach of confidentiality, and is talking about people and patients when other people are around. You have to be really careful, particularly in, you know, in the nursing home and all those places where you're talking. You never know who is going to be behind the curtain on the other side or out in the hallway or other things. Now here at the university, we get to use a lot of our information when we talk about athletes and patients, or athletes, in the terms or the context of education. And we are learning from the cases and the individuals that we see. But that doesn't mean that we can go to the student union and talk about it, or we can go out to the bar or wherever and talk about it. It has to be only in terms of educational purposes. And we still have to protect confidentiality and privacy in that. Okay? Speak confidential client in the hallways where unsuspecting family. Yeah, you don't want to be talking to a nurse and have family members out in the hallway and have you talking derogatory about people. That's never a good thing either. It's like talking about your friend behind the back. So, some of the things that you can do are in some of the different types of forms that either you may have created or you may have seen. We've talked a lot about these already before. Activity screening, PARQ, a waiver for anything that you do bad. You can sign this waiver that says, I'm going to treat you, and whatever I say goes. Or you can give them, on the other hand, you can give them form that talks about having consent and being able to consent to whatever treatment it is you're going to do. If they suffer an injury, being able to document that, an accident in your facility, a bloodborne pathogens incident, anytime like you're in a high school athletic training room and you want to log any kind of injuries or any rehabilitation that you do, notes and information to parents, coaches, teachers, whoever. Anytime you're in a PT clinic, they send notes sometimes to school, they send notes to coaches, because it's like the telephone game. Whatever I tell the football player, and I'm not picking on football players, it could be the soccer player, the tennis player, whoever. A lot of times what I tell them does not get back to the coach or to their parent. The same thing that happens to them. Whatever you tell the athlete sometimes does not get to the parent or the coach the way that it's supposed to. So it's always a good idea, if you want specific, explicit information about their condition or about what they can or cannot do or limited in doing, it's a better idea to write it down and communicate it that way. That way there's no problem. And again, anything is better than nothing, so document, document, document. Most people will have liability insurance. I know places like, the National Athletic Trainers Association, you can buy malpractice or liability insurance. Our students here are covered under the umbrella of underneath a certified athletic trainer, so they fall under the university's liability insurance. So when you go to work at a physical therapy clinic, let's say you go to Akron General or SUMA, you would fall under the big umbrella of their liability insurance. They can purchase it a lot cheaper based on the cumulative number of people. The more people you have, the lower the rates go. But if you are going to be, let's say Caleb is an athletic trainer and he works for SUMA Health System and Children's Hospital, or the University of Akron here is having a big wrestling tournament and they need people to work it. Okay? If SUMA is not working that wrestling tournament, then he has to have his own liability insurance supplement, because he is his own individual contractor for working that particular thing. So you have to be very careful, particularly athletic training, about doing those different types of coverages and events like Special Olympics, Senior Olympics, the Gay Games, huge wrestling tournaments like the Junior Olympic tournaments that they have up in there. It's always a good idea to have your own liability or your own personal liability insurance, and it's usually not very expensive. Because again, they're betting on the fact that you're prudent and you're going to be a good professional. Example of how they run for limits, $2 million per incident. That means if you maim someone or whatever the incident is, they'll pay up to $2 million with a maximum of $4 million total. Now, $4 million is not a lot of money if you kill someone, right? You're saying their life is worth $4 million for everything under the sun. So keep in mind, depending on how much you pay for your insurance, you may have limits that are as little as $100,000 that they'll pay off, or could be even more. And then you can also buy catastrophic insurance where you will, if somebody undergoes a like a paraplegia or a quadriplegia, it would pay lots of money for lots of time. We already talked a lot about ethics when Cooperman was here, about right and wrong and making good decisions and using confidentiality. So we got about 20 minutes. Let me go over just some highlights of risk management, stuff that we didn't necessarily touch on before, and then we will call it a day. So a lot of this information is from a man named Appenzeller, and he wrote a textbook and talked a lot about being able to stop risk, or from protecting yourself from things that can happen. And risk management technically is, there's an element of danger, and you want to be able to protect yourself from that risk. Because there's risk in everything that we do, inherent risk in anything that we do. Okay? So how can you manage and protect yourself? And we already talked about what management was earlier in the semester, being able to plan and organize and control. And then managers are the people that actually do that, direct and maintain, and with purpose in a cooperative effort. So what we want to make sure that you do when you're a manager or when you are in the position of assessing risk is to be able to prevent loss, whether it's loss of limb, loss of life, loss of property, loss of money. It's your job as a manager or as an owner to be able to stop all these things, because ultimately, if you don't stop all of these, they're going to hit you in your pocketbook and they're going to hit your employees in their pocketbook, right? Okay? So the focus of risk management is about preventing and being forward-thinking and trying to prevent accidental loss. Okay? And some of risk management is not necessarily due to negligence. Some of it is being able to anticipate changes in the marketplace and knowing, or changes with Obamacare, how is that going to impact my business? I have to assess the risk of doing nothing as healthcare changes or doing something. And again, we're not going to spend too much time on this part because Jonathan Cooperman already talked about, we already talked about legal issues in some terms. Cooperman already talked about ethics and morals and being right and wrong, and knowing that all three of those things go together. Just because you're ethical and moral doesn't necessarily mean that you're going to get sued. Just because you practice good risk management skills and you anticipate everything and you have a policy and procedure for everything doesn't necessarily mean that you're not going to get sued. Okay? Now, it certainly lessens the risk, and that's, you know, a lot of what insurance companies are about. They are hedging on the fact that things are not going to happen, or if they are, when they do happen, they're going to have so much money stockpiled that they're going to be able to do it. Okay? So the goals of risk management, when we talk about health care or allied health or health professions, is to prevent medical emergencies from occurring in the first place. Are we ever going to be able to prevent every medical emergency under the sun? Absolutely not. But if we have policies and procedures in place, then when we respond, we can lessen the severity of anything that's going to happen. Okay? The other things that risk management does is it offsets risks through management strategies and marketing strategies, or it transfers risks or makes sure that those risks are minimal as opposed, instead of being, you know, huge that they could be. Okay? Some different categories when we talk about different types of injuries or risk management stuff. Health, trying to decrease medical conditions or risk factors that can lead to problems. Now, we know from our discussions in healthcare, this is a huge focus or huge emphasis on the Obamacare piece or the Affordable Care Act. They are shifting their mentality to a prevention piece and trying to manage people's risk, because if we can manage their risk and make their risk much less, then we can cut out expensive procedures and expensive long-term care of them. But we haven't decided whether or not that's going to work yet, because we also talked about the fact that that means people have to change their behavior. And we also talked about the fact that behavior modification was really hard. Okay? So, injury, can we change conditions or situations that can lead to problems? Can we go through our facility and look at every piece of equipment and every traffic flow pattern and every bathroom and every being or every place in our thing to see if we can reduce risk so that people aren't going to fall or people aren't going to trip or people aren't going to get infection? Okay? And again, things like back injuries, bones, and abrasions and things like that. Okay? And what that means is that we have to think and plan, and we actually have to be able to foresee what's out there or what can happen. Okay? There are some inherent risks that we are not going to be able to do anything about. Some things that are out there are negligence. We hope that nobody in here is going to be negligent, but if you are, then you have to have a plan in place to be able to stop it. Some other things that, again, we're not going to be able to stop, perhaps, are product liability. That's a whole other issue that we haven't even talked about. Mostly in here, we have talked about treating patients with our hands and things like that, but we haven't talked about defective products that we might give our patients. Except for, do we talk in here about the hip recall of the pieces parts? That's a huge piece of product liability. Are the hip implants from J&J that we talked about. And then physical plants or physically our layout. Okay. One of the things that we also haven't talked about, because we've mostly talked about physical therapy clinics, but some, and this is an example of, you know, a risk that you should be able to stop, would be fraying cables, and you should be replacing these before they actually break on someone. But what we find is that sometimes it's cheaper if we don't do those things because we can't afford to do them at that particular time. Let me wait one more day or one more week or see so many more patients because maybe I can't replace that cable and I have to replace the whole machine. One of the other things a lot of times that happens with us is that particularly in physical therapy clinics where there's all kinds of equipment. How many of you have ever been in there where there has been a mother being treated and she has to bring in her Tommy Factor children with her to physical therapy? Anybody ever see that? When they bring their children to physical therapy because they don't have anything else that they can do with them. And you see how busy they are and the types of things that they get into. And they got the ball on the plyo back. And instead of throwing, they start throwing the ball on the plyo back, and the next thing you know, it bounces off the plyo back and hits the mirror in the back and makes a big old crack in the mirror, and then the worker goes to pick it up and the worker gets cut. Okay, so some of the things that you have to be careful about are people using the equipment the way it was intended to use it. And a good example probably could have been the guy that we put on the pec deck. The pec deck is meant to go like this to work on your pecs. It's not meant to put like this and have people go backwards, although it's pretty convenient because now you've got a great way to work rhomboids in the back. But, and again, that's probably not a misuse unless you find out that they have a propensity to dislocate their shoulders, in which case it's not a good use. So making sure that the people are using your equipment and things the way that they're supposed to be used. Is there another picture? You know, inherent risks, playing basketball on the playground and spraining your ankle, falling on the ice, you know, some things like that. So there are things that we can stop and there are things that we cannot stop. And we have to prepare for all the things that we can. Inherent risks, inseparable from the activity, can happen just be for participating, nobody's fault, negligence, the fault of the participant, or the fault of facility personnel for failing to inspect equipment. And then again, those are some primary examples. Defects in products or floor surfaces, things that we said. All right. Litigation Association Group Insurance Company from 1995 to 2007, health and fitness facility clients. There were 6,144 incidents of litigation, 2,395 actual claims. And this comes from a research study from that Appen and Zeller from the beginning. Okay? And these are some of their reasons why. Member malfunction, so people dropped weights on their own foot. They hurt their backs while working out. There were premise liability where people tripped and fell. There was equipment malfunctions where cables failed, balls burst, seats. Imagine the seat falling off a bike while you're riding on it, and how badly that. I don't even want to think about how badly that would hurt. But there are all kinds of things that can happen. People put machines together incorrectly. Here you go. Here's the new. You know, well, it didn't happen here, but you know, we open up new cartons and you know, follow the instructions, put the bike together. Well, if you're asking somebody who's not really very adept or mechanically inclined, you know, all kinds of things can happen. Treadmill problems, professional liability, and people did not instruct the employees well what they were supposed to do. Okay, this is a table out of that textbook. And this talks about the number of claims and what type of claims that there were. So you can make that bigger, and some of the ones are ones that we already talked about. 139 malfunction claims. Average payout was about $17,000 per malfunction claim. Again, if you have insurance, your insurance is, if you have malpractice insurance or insurance, then it'll pay for it. Total about $5.7 million. And this was known costs from litigation. Now, that doesn't include people who settled out of court who said, we don't want to go to court. So it can be expensive when something bad happens. Okay? And again, what you want to do is prevent that from even happening, going into a courtroom. Again, why is there an increase in litigation? And litigation means going to court. Because there's a ton of injuries. Think about how many of your patients and clients have never exercised before. They don't know the first thing about getting on a Swiss ball and staying on it or falling off. Okay? Think about how many people are on those balance things. You know, the things that are like this thick, and you know, line up on them on one leg and do, you know, activities like this. Think about how many people are on a Bosu ball, not on the flat surface, but you roll it over and you put it on the wobbly side so that you're all wobbly. And think about putting your 45-year-old, 250-pound woman on there and the things that can happen. Now, prudent people probably wouldn't do that for her because they know that she's probably never exercised before and she's going to fall off. But there are people out there that are not very prudent and injuries can result. So Lots of injuries, lack of education and risk management, not adhering to your own basic safety procedures, and believe it or not, there are people out there doing personal training who are not really, and not only personal training, fitness and wellness centers, exercise physiology, who are not prepared to be out there. There are probably athletic trainers and physical therapists and chiropractors out there who, although they may have a degree and a license, they might not have learned anything. I mean, I say that tongue-in-cheek, but you can say the same thing about physicians, too. It's out there. So being able to find that person. There is something out there called the National Center for Injury Prevention and Control, and they keep statistics just like there's the National High School Injury Surveillance, and they have all kinds of statistics about all kinds of injuries out there, what position people play, you know, and how many back injuries, and I mean, you could find every statistic under the sun that you want about high school injuries. The same thing for injury prevention and control. You could go to this survey and find what kinds of injuries are out there for racquetball, and how many people have lost their eye, and how many people have had detached retinas, and all those other things like that. 7 million Americans receive medical attention for sports and recreation-related injuries each year. If that is not a cry for having athletic trainers out there, I don't know what is. The problem is, who's going to pay for those? That's my little plug for athletic training, sorry. But the problem is, you know, somebody has to pay for people to be able to do those different types, be in those types of facilities. 30% of those injuries occurred at a sport or recreation facility. So if you are going to work in that environment, you don't necessarily have to be an athletic trainer, but you better have some policies and procedures in place and be prepared for somebody to have an injury, because it's going to happen. Okay? 20-year retrospective study of weight training injuries treated at United States hospital emergency rooms, 980,173 persons treated for weight training injuries alone. Now, does that mean that there are crappy instructors out there? Probably some. Does it mean that there are poor individuals out there? Probably some. It means a lot of different things, but that's a lot of injuries. Okay? For an adult, are you going to be an emergency room physician? You're going to be busy.
Yeah, I don't plan on it.
No. Orthopedics, probably going to be busy. Okay? Some of the things, poor adherence to safety procedures. If you want to get yourself in good shape, have and practice emergency care plans, screenings. We already talked about these. Here's some scary statistics. This is again out of that same research study. 110 healthcare facilities in Massachusetts were surveyed. 45% of them never practiced an emergency drill. 39% of them did not have any kind of screening member for any new member. 31% of those places had fitness staff that did not have bachelor's degrees. So I am telling you that there are crappy people out there, and you may work with some of them. That's not a bad thing, but you will be better. Another study in Ohio, 65 facilities, 53% of those facilities surveyed did not have an emergency action plan. I don't care if you have something crappy on paper. Something crappy on paper, call 911, exit the building is better than having no emergency action plan. It saves lives and it stops people from getting injured. We're almost done here. Poor academic performance, 60 through an entire course. This talks about content that's not adequately addressed in your academic programs. In research and graduate and undergraduate programs, 98 sports medicine and exercise science programs, 16% had legal and liability throughout an entire course. 62% it was within the course. 22% did not include any content on legal and liability issues whatsoever. So there are some people, your peers, that you go to school with in other institutions that don't get any information on emergency action plans on anything whatsoever. Okay? Some trends: increased use in the facilities, increases liability claims, increases in turn your insurance premiums, because the more claims there are, the way it goes. Cost of doing business: annual premiums in New York City Health Club, anywhere between $12,000 and $59,000 just for your insurance premium, so that if somebody sues you, your insurance will pay for it. So it's the cost of doing business. Risk management, some things. Through the rest of this, some of the things that we've already talked about, but it essentially talks about doing your analysis first to find out what techniques and what things you can do to reduce your risk. Select those techniques that are going to be appropriate for you and your facility, implement those techniques, and then monitor the results. If something doesn't work, then you should try something else, and you should evaluate and follow up with it. Okay? Don't necessarily just say, oh, well, we implement it, we're good, because just because you implement it doesn't necessarily mean that it's going to work. Okay? And throughout here, there are some other legal terms about loss exposure and about legal liability exposures and about proper supervision and things that you should do. And some of this we already covered in the legal liability exposure, about knowing your laws and legal cases and your precedent, knowing your standards of practice, knowing and following any recall for any products and things that you sell, and testing of machinery and materials. And then clinically, we already talked about most of these, as to what you can do for strategies to make sure that you cover all of your bases. And strategies, we already talked about these duplicative documents, developing a plan, and doing training, and following through with your plan. All right. There you go. Have a good Turkey Day. Enjoy your Thanksgiving. Tuesday, the Career Center will be here. So if you want to bring your resume and